This Appellate Defender Office for the appellant Bryce Dull. If I may, Your Honor, I'd like to reserve 3 minutes rebuttal.
3 minutes is granted.
Thank you. As I'm sure this court is aware, the main issue in this case is whether lifetime post-release for a sex offense committed by an offender who is under the age of 18 is unconstitutional. The Court of Appeals majority opinion stated that it was a close call, but ultimately held that lifetime post-release for someone who was under the age of 18 when they committed the offense was constitutional. The court relied on the idea that if Mr. Dull, if his post-release is eventually revoked for a felony and he's ordered to serve the remainder of that post-release, it would be for a felony committed as an adult.
This is a categorical challenge, correct?
Yes.
Yeah. Could you tell us the category that you're seeking to have your client be placed in? What is the category specifically?
Well, the brief argued that it was, let's see how I phrase that, because that has ultimately changed with your Mossman and Cameron opinions.
I want to hear from you what the category is.
It would be aggravated indecent liberties with a child. Ultimately, based on your decisions in Mossman.
A juvenile convicted
Right.
of aggravated indecent. You're obviously a juvenile is
That never
essential to you.
changes.
Okay.
Yes.
A juvenile convicted of aggravated indecent. Okay, thank you.
So, as I said, the Court of Appeals relied on the idea that he would be an adult when he committed a felony, presumably that would have revoked his lifetime post-release. And this court recently issued an order asking the parties to be prepared to speak about the amendments to the post-release statute dealing with revocation based on a new felony. And I guess the first question in that discussion would be, is that amendment retroactive? And I would argue that it is retroactive and it would apply to Mr. Dull. But that lifetime post-release, as applied to him, would still be unconstitutional, as applied to that category, because he would still be under some supervision for the rest of his life. And that's based on something that he did when he was 17 years old.
But that changes the analysis with respect to what you just mentioned about the Court of Appeals, about the sanction of life without parole on new felony. That's changed now.
It does. It changes everything, basically. But I believe that I still am of the position that lifetime post-release supervision is unconstitutional.
It's a restriction of liberty for life without
Any chance
of lifting those restrictions is what you're saying.
That's right.
Okay.
So we need to move off the mark that lifetime imprisonment is something to consider. It's just the fact that it's under supervision is your complete argument as to why it's cruel and unusual.
Well, I'm not even sure that that's the case, because subsection C of the post-release statute says that it still allows for revocation for the rest of the post-release period. So it could be
It could be.
imprisonment for the rest of your life. based on
If something
revocation.
else happened.
If you committed a new felony.
So there's a lot of mays and ifs involved with that situation.
That's true.
At least 3, right? If there's a new felony, if there's a decision to revoke, and then if there's a decision to apply the lifetime penalty.
Right, that's one side of the argument, that it could be for the rest of his life. I'm also arguing that the supervision part of it is...
That's for sure.
Yes, absolutely.
Okay.
And if it hadn't been for this conviction and the mandatory term of lifetime post-release, Mr. Dull would not have been subject to that. Any of those things. I'm happy to answer any specific
Well, I guess
questions.
I'm thinking there's implications for juvenile offenders that have lifetime implications, and I'm thinking that the conviction of an aggravated indecent liberties for criminal history purposes stays with him or her for the rest of their lives. What's the difference? And then that kicks in when there's another conviction for something else. Otherwise, it's a dormant kind of thing.
Right.
How's this different?
This is different for a couple of reasons. I would argue that the supervision aspect of it never changes. He will be supervised for something that he did when he was 17 years old for the rest of his life, unless the legislature changes that statute, which I'm not sure that they will. But secondly, the difference between it being on your criminal history forever and being revoked, your post-release revoked, the criminal history aspect will change your future sentence for that new crime. But this will be revoking your post-release for your old crime. So that's, maybe I'm not clear. But I think...
No, I'm just thinking there's a lifetime consequence
Yes.
for the conviction of this. So it's a juvenile offender is not just relieved of a lifetime consequence based upon the conviction.
No,
So that's not your argument. There's a distinction here.
The
It's
distinction
not
is-
all lifetime consequences.
no, Your Honor.
Isn't your answer that the criminal history doesn't restrict one's freedom? If you have a criminal history, you can still go to Oklahoma.
That's right.
If you're on lifetime post-relief, you can't go to Oklahoma unless your supervisor says you can go to Oklahoma.
Right. There's a myriad of things that he
So
can't
it's
do.
a liberty interest
Yes.
situation, isn't it?
The supervision part of it, definitely. In addition to that, the revocation of the post-release based on the old offense is a new aspect to it that I think just having it on your criminal history doesn't add.
I apologize if this is going to interrupt your argument later on, but could you address the penological concerns that you have about the philosophy of sentencing and how this does not address those?
Are you talking about retribution?
I am. Retribution,
Deterrence and
Deterrence.
all of those things. I think basically the Supreme Court, U.S. Supreme Court opinion Miller and Graham, they talk about those pretty in depth. I mean, basically all of these things are because of the immaturity of the juvenile defendant, his inability to make good decisions all the time because of a lot of different reasons, and how they are more susceptible to rehabilitation, potentially deterrence in the future, having grown up and hopefully learned from their mistakes. Whereas an adult defendant, maybe is a little bit more set in their ways, to get colloquial on you. So I'm happy to speak on any particular.
well, specifically, the Court of Appeals decision talked about recidivism, and of course they talked about addressing issues from some cases. And do you have any information about recidivism dealing with juveniles? Or?
Specifically, I don't off the top of my head, and I'm happy to.
Can we just make that stuff up like apparently other courts do that say sex offenders have a higher recidivism rate without having any facts? Because I mean, there is some evidence that juvenile sex offenders present a low recidivism rate. Mm-hmm. Can we just pick that out of a bar journal or a journal article, or I mean?
I suppose if you wanted to, I'm not sure the question there. I don't have.
Well,
any-
my question is, did you need to present that kind of evidence to make this challenge that your client was subjected to cruel and unusual punishment because he presented a low recidivism rate, so there wasn't any rational basis to do that with regard to him? Or can you just, it seems like sometimes some of these cases just take what the courts think is common knowledge and use that for rationale.
Well, I guess I have a couple of different approaches to that question. And I might be remembering the transcript incorrectly, but I think there was some evidence of him having gotten a sex offender analysis evaluation, and I think there was low recidivism.
But that's a little different because you're not making a case-specific argument here. If you were arguing the Freeman factors under the
Right.
first factor,
Which is why I
that
didn't
would
bring
be
that up.
germane. But what we're talking about is, as a category of offenders, are juvenile sex offenders subject to a lower rate of recidivism than adult offenders?
Unless the expert talked about that. Do you have any memory that the
I
expert
don't, and
talked
I can
about
look at
that?
the transcript while my colleague argues. I don't have that argument off the top of my head, and I don't know if that's information that's out there. As opposed to the Miller opinion and the Graham opinion saying that generally juveniles in general crimes maybe don't have as high recidivism. I don't know how as it applies to sex offenders. I don't know. If the court orders, I'm happy to look into that. I think that completes my comments generally.
I'm sorry, you have no further presentation on any issues?
Well, I'm not sure, I can't remember if this court took up review on issue 2. If so, I would ask that it be remanded back to the Court of Appeals to just decide the argument. I think that they decided it wasn't, there was no jurisdiction to review that, but based on recent case law, I would ask that that issue at least be remanded as well. Oh, actually, one more argument, I'm sorry. If this court thinks that it can't find lifetime post-release for juveniles unconstitutional, I would argue that it should at least be remanded to the district court. I'm stalled there. The district court to consider individual mitigating factors based on the Miller opinion, that the mandatory aspect of it should be done away with, and that they should at least review individual factors based on that juvenile. And if this court decides that it can't go so far as to say that it's unconstitutional, we'd ask that it at least be remanded back to the district court.
Would the district court have then the ability to, under your theory here, to consider individual mitigating factors? Could it modify the time of the post-release, or would it just be it'd be either or one or the other, either none or all of it?
I think that I believe they would have the ability to order an alternative, not just none or all.
Okay.
How can you say that?
Yeah, I'm just curious about that. How echo Justice Johnson. How do you say that, given your argument?
That I guess there is the argument that because, well, but you're not saying that lifetime post-release is unconstitutional in this instance. You would be saying that the mandatory aspect of it is unconstitutional, and so they could go back and order something different.
Well, back in the Gould age, when this court determined that upward durational departures were unconstitutional, then at least one district court attempted to devise its own scheme to get jury determination, and this court says no.
Okay.
District courts can't make up their own sentencing scheme. Their authority to sentence flows solely from the statute, and if it's unconstitutional, then they can't remedy that. And if this is unconstitutional because it's not individualized, then it's just unconstitutional. I don't think you can send back and let the district court devise a scheme to make it right.
I would agree with that. I guess I was thinking if it was sent back, he would be sentenced according to severity level 3 crime generally, but if you do find that it's unconstitutional, then I suspect that he would not have any post-release then.
Any more presentation, counsel?
Thank you very much.
Any further questions? Thank you, counsel.
May it please the court, David Loudon, Assistant District Attorney for the state. In reviewing this case, it's my understanding that we're here to review the majority decision in this case that the defendant failed to establish a constitutional deficiency in the lifetime post-release. I would ask this court to follow the well-reasoned decision of Judge Malone in the majority opinion. I think the judge hit all the highlights and reached the proper decision, especially in light of a case that came down from this court 3 weeks ago. in the Brown case. Excuse me. Didn't have the opportunity to print it off today. In that case, this court held that a juvenile offender who was convicted of felony murder could not establish a categorical challenge to a hard 20 sentence. In essence, finding that there's a distinction between a life without parole sentence and one where parole was eligible after 20 years. This case is very similar to that in that I think if you look
Well,
at...
this case is about life, though.
This case is not about life, Your Honor. This case is about lifetime supervision, and therein lies the distinction. The distinction is that...
It's just a matter of degree. I mean, the liberty interest of that juvenile is restricted for the rest of their life. It's just a matter of degree, whether it's in prison or whether it's restricting their movement out of state or restricting their ability to have a beer, but their liberty interest is restricted for the rest of their life.
Well, there's no doubt, and there's no doubt that can be viewed as harsh under different circumstances. But what we're here to decide today, Your Honor, is can we say that in every single case where juveniles involved and that there's aggravated indecent liberties, that this is categorically unconstitutional? So for every juvenile, I would submit that it would come down to a case-by-case basis. That would be more appropriate. In this instance, we don't have that. And as I was saying, the difference we have here is that the juvenile here has the keys to the prison, essentially.
Well,
if he does,
what we're really talking about is Miller and Graham, our U.S. Supreme Court, said that the juveniles are different than adults. And we have some literature that says that juvenile sex offenders present low recidivism rates. And let's see, the Federal Advisory Commission on Juvenile Justice said research has confirmed that juvenile sex offenders generally are less likely to reoffend than adults. And since we have our U.S. Supreme Court saying there is a difference, and we have the data indicating that there's a difference in recidivism, how do we say that there's a rational relationship now between lifetime post-release and the juvenile offender?
well, I don't know what study you're referring to, Your Honor, so I'm a little bit of a disadvantage, and I do know
Well,
that...
it was in the brief. I'm reading from the, well, no, it's not in the brief, sorry. That was some other data. But anyway, there's data out there that indicates that there's a difference in recidivism. Plus, we have the U.S. Supreme Court saying they should be treated differently. So why don't we treat them differently?
Well, I think the question is not necessarily whether a juvenile is less likely to offend according to, a study. The question is there a rational relationship between the lifetime registration and the goal that it's trying to achieve? And this court has already recognized, as far as adults were concerned, in Mossman and Cameron, that the lifetime post-release did advance the goals of rehabilitation and incapacitation with regard to sex offenders who are of a different ilk. Even if they are less likely to offend, I don't think the study, and I don't see it, and I'm not aware of one, that says that they're more or equally likely to offend as somebody who commits second-degree murder, for instance. So I think there is more of a propensity, and I think to suggest
Well, when you say
otherwise-
propensity, then you're talking about recidivism, aren't you?
Absolutely.
Okay. So the penological goal here, designed by the legislature, was to reduce recidivism. by imposing a lifetime supervision.
Right, well, incapacitate and rehabilitate, Your Honor. And that's something that was.
You don't necessarily need all of them. Is that what you're
Absolutely
saying?
not.
Right.
Absolutely not. And I think there does have to be some rational relationship, as you're saying, Justice Johnson. I just think that, here, simply because a juvenile may be less likely to reoffend than an adult in a sex case, it doesn't mean that we're not advancing or providing a rational relationship or rational basis to have the lifetime post-release supervision. I can't tell this court that this isn't a harsh thing. It is harsh, but
Excuse me, on your rational relationship, I mean, I recognize that as a factor in equal protection analysis. Is that part of, is rational relationship what we're looking at?
well, Justice Johnson
An Eighth
mentioned
Amendment
rational
category?
basis, and that's the only reason I'm bringing it up. That there is a link here, and we're looking at this and determining whether this is just some penalty without any basis whatsoever.
Okay, you're
I assume-
relating it to the penological goals to be
Right,
served. Okay,
right.
I understand now. That phrase is a term of art and it's confusing.
You're
me
right.
for
You're
some
right, Your Honor. I did misuse that. so.
Okay, I understand.
Does the amendment help you or hurt you, or and is it retroactive, or is it?
Well, I mean, to the point of their argument that somehow, if these conditions precedent being more crime committed by the defendant, if those are in place, then it certainly does help me because that's the only way he really gets back there. I mean, he can, I guess he can commit a conditional violation and perhaps make it to that point, but it's far less punitive, I would say, for lack of a better word. As far as the amendment, I would love to stand up here and argue that the amendment does apply. That would help me out potentially. But in looking through it, I can't say with 100% certainty that it is. What I know from this court's previous jurisprudence is that the intent of the legislature controls. We look at the language used by the legislature to determine whether there is retroactivity. And in this case, I'm not aware that there's a retroactivity provision. That could end the inquiry if the language is clear. But we could move on to whether it's substantive or procedural. It would be substantive if it altered the penalty for the crime. Here, what we have is the term of life post-release is not altered by the amendment. So there could be an argument that there is no, it isn't a substantive change, it's procedural. However, if you look at the effect of what the amendment does, it allows a change in how the defendant is going to serve his time, whether he will be in a prison or whether he will be subject to release. To that extent, it would, I think, would go to a change in the way the so-called punishment is meted out. So I would argue that it is a substantive change. I could certainly see the other side of the coin, however.
I'd like you to address the other argument, the alternative argument about individualized sentencing and U.S. Supreme Court precedent on that. You said a moment ago, in the course of your argument on the Eighth Amendment categorical challenge, that it might be better if it was individualized, or it might be better if it was case by case, I think is the phrase you used. Do we have a constitutional violation just that because it's not individualized, because it's always mandatory?
Let me try to set this up so I make sure I understand your question.
Okay.
My understanding is that the only reason we're here is because it's a categorical challenge. And
That's correct. Is there a problem with individualized, not being individualized because it's mandatory in all cases?
you're saying from a scheme point of view, and I'm assuming that you're recognizing that if you're in a Freeman analysis where we need facts,
Yeah,
that we're going that way.
that's different.
Right.
Yeah. It's just as a mandatory nature. I mean, you talked about it being mandatory the other way. Does being mandatory lifetime post-release make a difference? for juveniles or not?
I don't think so. And again, I think this goes back to the situation where there are some conditions preceding that are required before that kicks in as far as the penalty part. But if you want to isolate it to...
I mean, there are ways in which juvenile status affects prosecution, but not this part of the sentence. That's driven specifically, right? By the
Right,
fact that it's aggravated
because this person was mapped. Without the map, with or without the map, we couldn't put a life sentence without the possibility of parole. This person, who was 17 years old, was mapped, and you're saying that that really doesn't have any bearing. You're questioning whether that even has
I'm
any
just
bearing.
saying, do we have a problem because it's mandatory?
I think, didn't the U.S. Supreme Court say it doesn't have any bearing? That kind of a process in a state is not enough to answer the question at the sentencing.
The mapping
about the-
process?
Yeah,
Correct. I think that's clear, yes, because they're just looking at the age and saying,
right.
regardless of whether you went through there or not. I do think that that process would be relevant to some point if we're just simply looking at, down the road if we're going to do a Freeman type analysis.
But
I'm sorry.
Yeah, back to that question. I interrupted that, but I want you to get back to it because do you read Miller and Graham in combination to tell us that you have to have individualized sentencing of juveniles to be constitutional?
I think individualized sentencing for juveniles with respect to the question before the court, I don't read it as being in every instance, especially where, if it's a given that life with parole is different. I don't know how that situation for a juvenile, why that changes anything as far as whether it's constitutional or not. I mean, you're suggesting that if there isn't a complete review of everything in the case to determine whether a juvenile can get a life sentence or not, or lifetime post-release supervision, then that's somehow unconstitutional. And I think that's a stretch read of what they would find by the U.S. Supreme Court, simply because from a categorical basis, once again, where does the penalty lie? I mean, so how much is enough? I mean, at what point does do these legislatures get to determine how much is enough? And I don't think the U.S. Supreme Court has gone so far as to say, okay, you can't put 30, or a lifetime, but maybe we go 50. Is 50 enough? That keeps them in there long enough. I don't think they're getting into that debate about if you can't do life, that you have to come down in years. I mean, where does it end? And I don't think that the court is saying you have to look individually at each one simply to impose a proper sentence that doesn't violate, the prohibition against having the death penalty, the prohibition against having lifetime parole sentences without parole for non-homicide crimes. I don't think it gets into that, and that's why I think it's... No, I don't think it makes a difference. I don't think you have to have individualized sentencing to impose a sentence of this nature, especially when part of the sentence in this case was, a 45-month sentence. I mean, if you want to look at the facts of the case, there was an individualized sentence. The court downward departed from 90-some months to 45. And then part of that, we want to segregate this lifetime post-release, but I think we have to look at the entire sentence as well. As far as, if there are no further questions on the first issue, on the second issue, I would agree with counsel that there is a new case that seemingly would place jurisdiction in the court to raise or to analyze an issue regarding consecutive sentences. I guess if this court is willing to take the Looney case to the point where if there's any departure sentence given, then a defendant may challenge that sentence, whether the defendant is challenging that departure itself or the concurrent or consecutive nature. I certainly would like to put a halt to that, but this court doesn't seem to be inclined to make that reach, but I would ask anyway to do that.
How, on what basis? I mean, do you think the statute allows us to draw some distinctions?
Well, no, I don't have a good argument against the Looney. I'm just up here asking, Your Honor. I do think it opens the door. I don't have any wonderful analysis to tell you that what you've reached in Looney was wrong, other than the fact that we proceeded under that way for a long time. And from what I read in Looney, I mean, what you're telling us is this is a legislative problem, not a judicial problem. So we're just looking at the language of the statute. I don't see any opening for concurrent or consecutive sentences to get by Looney. I don't have anything to make you change your mind on that. So.
I see you're out of time. Do we have any further questions of counsel? Any further presentation?
No, Your Honor.
All right. Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you. I'm happy to answer any questions, but if there are no questions, I'd waive rebuttal.
Any questions? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.